Suspended Public Protector Advocate Busisiwe Mkhwebane has lost her High Court bid to remove the chairperson of her impeachment inquiry, Dyantyi. Advocate Mkhwebane is standing by to speak to us in terms of more on this judgment. Thank you very much, ma'am, for your time this morning. Maybe let's get into the heart of your application.
Thank you for the time and for inviting me, and to your listeners, good morning.
Just maybe let's get a little bit of a background and get into the heart of your application and what it was about.
Yes, as you'd know, that I brought an application to the Western Cape High Court for Mr. Dyantyi, the chairperson of the Section 194 committee, to recuse himself, and Mr. Mkhwebane. What they did is that they refused to recuse themselves, and the application was based on the fact that me subjecting myself to their kind of abuse of power and worse. So you remember, on the 13th of September, I was sick. They even refused to, or they proceeded and they cross-examined, or they questioned one of the witnesses. So, and Mkhwebane being the husband to the complainant, Ms. Mazo. So the application was for them to recuse themselves.
Page 9 of the judgment reads...
Are you still there?
Yes, ma'am. Just maybe let's take a look at page 9 of the judgment, which reads, on the 20th of September 2022, after approximately 30 days of hearings, the applicant, being yourself, delivered an application in which the recusal of Mr. Mkhwebane on 3 grounds and the recusal of the chairperson on 12 distinct grounds were sought. The matter was argued before the committee on the 21st of September 2022. The committee then met to consider the applications and resolved to seek an external legal opinion on their merits. On the 10th of October 2022, the opinion obtained concluded that there existed no basis for recusal, but you still maintain there is. Let's get into the recusal of the chairperson and the 12 grounds. Perhaps if you can highlight maybe the 3 most important that stand out for you.
Yes, that's why the recusal was based on those 12 grounds. But the most important thing was that the chairperson refused or proceeded to hear the matter, irrespective of the fact that I was sick, and as well proceeded to hear the matter when my legal team was not present. But what is very important here for people to consider is that now the issue out there, it's like the chairperson and Mr. Mkhwebane were exonerated. I've seen the interview on ENCA yesterday night. The chairperson apparently said they feel vindicated and they are doing everything fine. And the recusal of Mr. Mkhwebane was based on the fact that he's married to Ms. Mazo, the complainant. And as well, our application was based both on the violation of the Promotion of Administrative Justice Act, which is BAJA, and or the principle of legality. What's very important here to Duzile is that the judges, Judge Ali, Klute, and Savage, they said it themselves that they didn't deal with the merits of the matter. I mean, if you can go to from paragraph 48 of the judgment, where we indicated a lot of irregularities. They didn't deal with the merits of the matter. Their argument is that taking the argument of the respondents, that I would have an opportunity to take the report of the committee on review. Imagine, I'm just being subjected to this abuse. I feel that the two are conflicted. The two are abusing their power. And now the judges are saying I must just be subjected to that abuse. What's worse is that they even say that Baja or the principles of legality kind of do not apply to the committee members. Yes, it might apply, especially the principle of legality, possibly to Parliament, but then it doesn't apply to committee members. It means then those members of the committee can go ahead and violate the Constitution as much as they would want to, and I would have to be subjected to this particular problem. So you'd read paragraph 58, for instance, of the judgment. It says it is not necessary, given our finding that the applicant has sought relief in medias res to determine the test for bias in proceedings before the committee, or whether a case of bias has been made out against the chairperson and Mkhwebane, or whether the issue complained of by the applicant concerning widening the scope of the inquiry is a violation of her rights. I mean, and they are even saying they don't see anything wrong for the committee to proceed, and there's no grave injustice. I mean, I was sick, they proceeded. Hence, I even said, even the worst criminal, when they are sick, the matter will be postponed. Now, the very same wife who's the complainant, the husband is sitting on the inquiry. I must just feel, and the husband never even declared that to me so that I can decide whether I can proceed. What's worse here is that even the very same judges, Judge Savage raised the issue before the hearing that she has worked with Advocate Bauer in several other work and engagements, and they were asking whether am I willing to proceed with him being part of the panel. You know, they told me before the hearing, and I said it's fine. So the very same thing which was expected from Mr. Mkhwebane.
Hello again. We speak now to Advocate Busisiwe Mkhwebane. She went to the court to try and have the committee chairperson, Mr. Dyantyi, recuse himself or be removed from the process looking into her fitness to hold office, and a court has disagreed. But Advocate Mkhwebane, thank you very much. I understand you are back with us. We were going through paragraph 49, and you were explaining in terms of perhaps your understanding of what the judge here was saying. On paragraph 48, it also reads the applicant's contention that she is aware of many more irregularities that occurred during the proceedings, but has elected to raise only some of them in this application, reserving her right to raise others later, underscores that this may not be the last application brought before the finalization of the inquiry, and that the real risk exists that the applicant intends to engage in piecemeal litigation, which would only serve to delay the finalization of the matter. And then Rule 129AD2 of the Rules of the Committee provides that the committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time. You have pointed out, and you've been at pains to point out, that this matter is not fair, or the procedures that are being followed are not fair. The reasonable time, or within a reasonable time, what do you perceive is going on? Because your term comes to an end in October of this year.
You know what, Juduzile and listeners, I think what is happening is that it's not true that I'm intending to litigate in piecemeal. I mean, this judgment exactly, they are promoting that, because I came to them and I said, I cannot continue to appear before this bias committee, meaning people who are continuously violating my rights, people who are biased, who've even commented even before about my incompetence, especially the chairperson. So the fact that, yes, it doesn't only focus on reasonableness, it also says the process must be fair and the process must be conducted in a reasonable time. Definitely, that's the question. I mean, if they listened to me at the beginning last year, July, where I said with my legal team that they cannot expand the scope. Why did they expand the scope? Because if they only focused on the 3-panel member terms of reference, we wouldn't be sitting here, because we would have, the matter was going to be finalized long time ago. Now they extended this committee to be like a CCMA. I mean, 10 to 15 witnesses were called just to focus on HR-related matters. And this relates to only 4 cases which are before the committee. And as well, if they agree that we are not going to regurgitate, and because the main issue was what process did I follow and whether I am competent and whether I can do my work, irrespective of the fact that there is only these 4 court judgments out of the 412 reports or which one has issued. So the main issue here, the judges just took the easy way out and said, no, just continue with the process. There's no proof that there's grave injustice, and then it means I must just continue to be subjected to abuse. They didn't deal with the merits of the matter. Hence, I was saying to you, let's read, if you will go to other paragraphs, especially where they are indicating that I will still take the matter on review, and the fact that they are saying members of the committee, they are not subjected to perjury in a way. But then the fact of the matter is they should be subjected, or they should have insisted that the committee, the chairperson and everyone, they are bound by the constitution, irrespective of whether they are doing this work on behalf of the National Assembly, which is another arm of the state. But the main thing here is that they didn't deal with the merits of the matter. So it's wrong to say that they are exonerated, because they are saying here, no, the application is dismissed, and when the matter is finally dealt with, it means they can continue abusing me, and when I'm dead, then the matter can be brought back to them to decide whether they were indeed biased, whether indeed they violated my rights.
Yeah, I'd like for us to hone in on what you speak of in terms of you having to prove grave injustice, because paragraph 40 of the judgment reads, it is only in rare cases where grave injustice might otherwise result or where justice might not by other means be attained that a court will entertain a review before the conclusion of proceedings. Such judicial intervention is it medias res, has been said to be warranted only where there is gross irregularity in the proceedings, and in a rare case because the perpetrators perpetuating the irregularities are those that have been entrusted with safeguarding constitutional rights. What would a rare case be, and what would satisfy the courts that there's been a grave injustice, do you perceive?
You know, that's a very critical paragraph, Duduzile, you are reading for the public to even see. So a rare case or an injustice where I am sick, I couldn't appear before the committee. And then I'm told that is not a grave injustice. And where my legal team, which the Constitutional Court said I should be represented, they were not present. The committee continued to do their work on the 13th of September. And the issue of Milham having not declared that he is the husband to the complainant, what do you call that? Is it not a clear violation of my right? And remember here we were saying the issue of the perception of bias, even if bias is not there, but I feel I won't receive justice because they are biased. I mean, that is a clear case. We've even shown them various cases, even the Constitutional Court cases, where we were showing that you cannot have people continuing irrespective of that. So I feel my rights are violated, but then the judges themselves are saying this. And I think if you go down, there's a paragraph where they were even saying, no, maybe another court might reach, or when the matter is reviewed, reach a different conclusion. So hence I'm saying to you, I must just sit there, be abused, and just those members abuse their powers. I mean, even the chairperson having commented before at the Justice Portfolio Committee that this is incompetence. Now you take the very same person to come and judge, unless then they know that they have already concluded on this particular matter, because yes, I've heard the chairperson yesterday or in that clip saying they will send the report with findings and recommendations to Parliament. I mean, if you say that, it means it's a done deal, it's a concluded process on their part. But then I feel this judgment, unfortunately, the judges didn't deal with the merits of the matter. They just took the easy road of just concentrating on the technicalities and then indicating that I will exercise my rights later. But Mina, I feel that my rights have been violated, and this is a rare case. I mean, if a person is sick and you just proceed without the person being there. Hence, I'm saying even the worst criminal, when they are sick, the magistrate or the judge won't proceed with the matter. But why am I being treated like this? I mean, and even the courts feel that it doesn't justify for me to apply for this. The worst case to do, Zile, is that yes, they didn't grant the personal costs, which unfortunately that's what is being done, which anyway corrupted. Why go ahead and say I must pay the costs of the 3 counsel for the respondents? Why? Because I brought this matter on my own, and worst part is that I'm in this situation because I am the public protector. I would never have appeared and litigated if I was any other person who's not the public protector. So now these judges, they mentioned the issue of personal costs, but then now they expect me to pay this cost. Hence, we will be appealing, especially why go ahead then issue costs? Why they didn't say each party must pay own costs?
Right.
Where would I get the money? Trying to exercise my rights here, which are violated.
Advocate Mkhwebane, in just closing up the conversation, I'd like to just go a couple of steps back in terms of the judgment and the context that it sets out. Page 20 reads, the committee began hearings on 11 July 2022. On the 12th of July the same year, the applicant indicated that she was participating in the proceedings under protest, including because the chairperson could not be impartial as he was a member of the African National Congress, or the ANC, which had unanimously voted for the establishment of the inquiry, and he was not suitably qualified. However, she indicated that she had decided not to ask for his recusal on the basis that this would have been viewed as frustrating the inquiry. In retrospect, and from what we've been hearing from you consistently, it would appear that you are being frustrated. Do you regret the decision at the time?
You know what? I regret, yes, for agreeing to do this, because even my legal team, I think in one of the sessions where Advocate both indicated that I've been saying to them, we cannot be proceeding like this, let's just go to court so that this matter can be decided from the beginning. But they paid because, again, you find people accusing me of delaying the process, Stalingrad behavior, and not wanting to account. So I participated, indeed, under protest, and I'm still repeating, this is the treatment I'm receiving. And even currently, what is happening, that's the greatest violation of my rights. I mean, the chairperson just continuing with the evidence leaders and treating me the way he treated me, with such disgust, I must say. And you are then coming back and saying you are fair, you are dealing with the process in a fair manner. Whereas you are not doing that, because you need to be seen to be doing the process in a fair and justifiable manner, which is not. So unfortunately, I am subjected to this particular process, and I'm proved right, because all the incidences which I've mentioned, indeed, they prove that this process is just having a foregone conclusion of what they would want to achieve. And, well, on my part, I am thankful for whatever is happening, and I'm thankful that I'm appearing before that committee as well, so that I can take the public into confidence of how I conducted my investigations and the evidence which was before me. So I think, unfortunately, it's not a fair process, and I must still say the abuse is still continuing, irrespective of the fact that the courts are saying I must just subject myself to those, especially the chairperson, who's conducting himself the way he's conducting himself.
Advocate Mkhwebane, one would be forgiven for thinking that perhaps this is a sideshow because some of the information that is being dealt with at that committee is quite explosive, and it's information that will help people piece together some parts of the puzzle, because when you left it, you were dealing with the CR17 bank statements. And so what does the public need to understand about crucial evidence that you need to be there to present or to defend or to explain, or whatever it is that is needed so that the everyday person can make up their own mind? What should we understand about that evidence now that, because that's what the chairperson is arguing, that, well, they're helping the advocates that are there, are helping them understand, or helping the committee understand and with this process?
That's a very strange argument. I mean, using the committee meetings and sneaking in the evidence leaders. Remember, I'm still testifying. I am still on the stand. That is a travesty of justice, where you wouldn't even, in a simple case where you appear in court, you are still on the stand, and the prosecutor decides to, and the magistrate, because you are sick, they just decide to proceed with the matter and deal with the evidence. That process was still going to be dealt with at the right time, because what the evidence leaders are doing now, it's legal arguments. They are going through all the evidence which is there and punching holes in whatever I presented. That they are allowed to do after I've completed testifying and after they have cross-examined me, and then the committee met. Maybe when they were cross-examined, when it's time for them to cross-examine me, and I clarify all those issues against the background of what I dealt with, because they continue to even confuse the committee more. You see, even Advocate Bauer doesn't even understand the very same code, the way he was mentioning it, but that's another issue. And I didn't follow the whole presentation, but the fact of the matter is I was supposed to be there with my legal team and object. This is a wrong process. It's not even provided in their directives what they are doing. So that matter will have to be taken again back to court for them to decide. But I'm doing this as well to expose and show how I am being dealt with and how the precedence is being set by even the courts on such matters. And I hope that the same thing will come back and be used against the others in the future, because this is the first time this is happening. So it's wrong what they are doing. That matter was going to be dealt with at the right time, because I was still going to finish my evidence, be cross-examined by the evidence leaders, and then they could raise all those issues. And thereafter, the members asked me questions. After that, then there's legal argument, where the evidence leaders will bring all their arguments, my legal team will bring the argument, and then the report is compiled. I am given an opportunity to comment on that report. So that's the process. Now, why rush to do this and just poison committee members or even whoever would want to just publish the information out of the blue? Because there's an explanation for every process which took place.
Thank you very much, Advocate Busisiwe Mkhwebane, for your time this morning.